I've been working on a manuscript way too long, and I've been reading through case law that deals with, during the war between the states. And it's really fascinating. And there's just such a corpus of litigation and case law that it's very hard to process all of it and keep it all straight. But for those of you that, case law is essentially the written opinions of appellate courts. So I'm looking at state Supreme Courts primarily from 1861 to 1865 to get an idea of what the South was doing vis-a-vis the rule of law during this horrendous life and death struggle they were engaged in. And it's really fascinating because it shows the commitment of the Southern people to the rule of law, and which is very important insofar as individual rights, liberties, so on and so forth. That it's really fascinating because even let me give you an example. The lawyers did not go to law schools. They didn't exist yet. So they had classical educations. And they would study Greek, Latin, all the classics, philosophy, literature. And they would graduate from a university and then be an apprentice, and they'd work under someone. And after apprenticing, the lead attorney would stand in for them and say, yes, this person's qualified, and they'd be admitted to the bar, so-called. And they'd be practicing. And that's why, as I read these opinions, they're written like, almost like novels. They're very fascinating. The writing's excellent. There is a lot of technicality. There's a lot of Latin that's difficult to wade through. But these were men that were committed to the rule of law. And this goes from civil law to criminal law. I've learned so much about the South just by reading these opinions, something you wouldn't read from an academic treatise on the South. These people were there. And when they write and adjudicate a case, they give you the facts. So the elements of a brief, so-called, in a court opinion would be, you start with the citation, because I know this is going to be recorded. And some of this, towards the end of the war, paper was in short supply, so they were writing some of these opinions on wallpaper, just for the record. Because case law is controlling precedent. So when a Supreme Court in a state writes an opinion, adjudicates a case, all the lower courts within that state are to follow that ruling. So it sets the standard of what a particular case with similar facts and legal issues, how the law is to be applied. So you have the citation. They know this is going to be recorded. They would explain the facts of the case. Then they would address the legal issues pertaining to those facts. Then they would make what we call a decision and action. The legal issues are usually yes or no to a question or two. And then the action would be reversed, remanded, affirmed, whatever the case might be. And then you would have the opinion, the rationale, why they're writing or why they decided the cases they did. And so that opinion pertains to the legal issues that they're addressing. And if there's a dissenting opinion, then you would have the dissenting opinion. And then at the end, you would have the final, affirm what the lower court from which this case originated came from. So the case I thought we'd take a look at today, and there are so many, my gosh. And I'm focusing primarily on Florida because there's just so much, and I know many people don't read, and people in universities don't read, and they're not going to read about the South. So I'm trying to make it in such a way that people who do read it would get a sense and draw from it and benefit from it like I did. So, for example, there are a lot of probate cases entitled to a who owns a slave. And So, for example, if you read between the lines, you could actually make a legal argument that slavery never did exist in the South. Because when you think about title to property, it can't be based upon fraud and violence. And the courts consistently across the board say that slaves, so-called, are sentient human beings with rights. And in capital felony cases, to every state made the point that in a capital felony case, the slave, the defendant slave, has the same rights, substantive and procedural, as a white person. Now, that's not what we've been taught. The image is that the slave was chattel property on the same level of livestock, which simply is not the case. And the case we're going to look at today is sort of a horrendous case. The facts involved murder, sexual impropriety, all sorts of things. But before I do that, to give you an appreciation of the case, started in 1857 and extended through 1861. So even during the outbreak of the war, Josephine, a slave, charged and convicted, and the facts bear out the conviction was correct. She murdered the deceased through arsenic poisoning because of jealousy of the mother, the wife of the person with whom she was having sexual relations. And this wasn't the first rodeo for them. The master of Josephine's previous wife died under similar circumstances. So you could think about, in Mississippi, 1857, a slave murdering a young lady, a young teenager, and you would think, based upon what we've been told, she'd be within a few hours whipped, beaten, and strung up at the nearest tree. Not so. Which speaks a lot about the community, the organic relationship. So I'm going to go through just the steps. Now, this isn't particular to that case, but these are the steps that every criminal, especially capital case, has to go through based upon American jurisprudence. And this is applicable, it's in the facts of the case, in the Josephine case. And this is, I just picked this one out. There are so many, it's just, phenomenal. So, you first have an arrest. An arrest is the initial stage in the criminal process in which an individual accused of a crime is taken into custody. Now imagine, and I don't have time to go into it, but this community, this family, includes both slaves, free blacks, and whites, the neighbors. And the judge goes through the facts of the case that are in the amicus briefs, or the briefs to the appellate court, about how the slaves were moaning and wailing at the death of the young lady. So you have an arrest, you have this horrendous crime. Josephine was accused, along with the co-defendant, of the crime. They're taken into custody. So remember, this wasn't witnessed by a police officer. You have all sorts of things that are occurring. We're talking about arsenic poisoning, and the judge goes into the science mid-19th century science of arsenic poisoning, it's amazing. Because you have to prove a capital case beyond a reasonable doubt, not just based upon the preponderance of the evidence. So beyond a reasonable doubt. So they're going through all this. Was it arsenic poisoning? Did she die from arsenic poisoning? Was she previously ill? 1857 up through 1861. So you have an arrest and all this commotion. The second step are the charges. Following the arrest, the individual accused of the crime is held in detention as to the judge and the law enforcement are coming up with charges. Now, they have to have probable cause to charge Josephine and the co-defendant. So there's a lot of motion going on here. And that's called due process. All of this is due process. So general information about the circumstances that led to the alleged crime, detailed information about the crime itself, statements provided by and corroborating witnesses. So they're collecting testimony, witness testimony from slaves, non-slaves, free blacks. They're doing their due diligence to build a case, because this is the state versus Josephine, and then on appeal, Josephine the slave versus the state. Okay, so they collect these this evidence from witnesses, and some of the testimonies conflicting, so they have to sort it out. With this report and information in hand, the prosecution makes a determination as to whether an actual crime has been committed and whether there is probable cause to believe the person in custody is guilty of the offense. It is at this stage the prosecution also determines the type and severity of the charges to be filed against the individual. In other words, was it intentional? Was it malicious? Was it premeditated? Was it accidental, which would be manslaughter? So they have, now remember, the prosecutor's elected, the judge is elected, the state Supreme Court judges are elected, they're accountable to the people. It's not like in the federal system, they're nominated, confirmed, and have lifetime tenure. They're accountable to the people. Okay? So, after that, there's the arraignment. Now, I'm not saying this is, Josephine's being treated well. I teach in a prison. I run a project. They're not being treated well today. So I'm not saying this is, beautiful. This is a tragedy. So the arraignment, as soon as possible after the arrest and determination of charges, the person accused of the crime must be brought before some court or judicial officer, generally referred to as the arraignment. So the charges are read to the defendant. Now keep in mind, there are attorneys appointed by the government to represent Josephine. These attorneys are white because it's a capital case. So you see all the moving parts. Accused slave, horrendous crime, due process. Here comes the attorney to represent. And man, did they represent. Because she actually prevails in the Supreme Court on a technicality involving a flaw in the prosecutor's indictment, even though she was guilty. So the judge says, new trial. So you have the arraignment. During the arraignment, the charges against the defendant are read to the defendant. The court advises the defendant of his or her right to counsel and the right to remain silent during the process. Now, the right to remain silent is for today, but you also had, it wasn't a right, but an option to remain silent. Okay? The pre-trial proceedings. Now, this isn't stretched out like it is today. This is happening in a much, shorter time frame, because the judge might be riding circuit and he's going to be there for a certain time. Before any actual criminal trial, these are the pretrial proceedings, the criminal process provides for a period of time during which the prosecutor and defendant, through the defendant's attorney, exchange information about the charges and alleged facts of the case. Okay? So there's communication between the prosecutors and the defendant's attorney. And this is known as the pretrial. Now, that doesn't mean it's all in the up and up. Even today, there's so much prosecutorial misconduct. I mean, by the way, the prosecutor's probably one of the most powerful politicians that has power over you. And most people don't even know it. Prosecutors, state attorneys are extremely powerful, and sometimes highly corrupt. The court will instruct, so the prosecution has its case, everything's going, getting ready for trial. The criminal trial is the stage in which the actual criminal guilt is determined. If the defendant has requested a jury trial, prospective jurors are questioned to determine if they can reach a fair and impartial verdict. So you have the option of a bench trial, just the judge, or a jury trial. Josephine eventually opts for the jury trial. Now, that means she thinks she could get a fair shake, because you impanel a jury to make, decide whether guilt or innocence. So try to picture this. 1857, 1858, I mean, it was a different world insofar as, the comforts of life and communication. So after the jury is selected, and you could imagine that process, each side offers an opening statement. Generally, the prosecution goes first. The prosecutor gives a relatively brief overview of the crime, a general view of the evidence that should convince the jury that the defendant is guilty. The defense then offers its opposing view of the case. Now try to put yourself in this courtroom where Josephine commits this horrendous crime. She's apparently a very attractive lady. And all this, the commotion in the courthouse, outside the courthouse. The court instructs the jury as to the law and provides it with questions to be answered as to the guilt of the defendant. The jury retires for deliberation. And then comes the verdict. In the criminal trial, the jury must deliberate and reach I think it was unanimous, I'm not sure, because the records are kind of sketchy, but needs to reach at least a majority of the jury has to judge the defendant to be guilty. And if there are multiple charges, it must render a verdict on each charge. And there are cases during this time period in state courts where the person's guilty of sin, but the charges were wrong. So, for example, there are cases where the person's charged with a felony and everything's, fine, and then the law, the criminal code to which the prosecution charged the defendant, upon which he was guilty, didn't exist. He left out a couple words in the statute, in the criminal code. So the person was acquitted because he was charged for and found to be guilty of a crime that didn't exist. What he did was criminal, but it wasn't in the criminal code. So, I mean, think about this. These people took their responsibilities, very, very seriously. So the jury deliberates, comes out with a verdict on each charge. Then comes the sentencing. Now, during this process, the defendant's attorney is making objections throughout, and those objections could be overruled, and most of them are. But after the verdict is issued, you can't object. You have to make an objection prior to the conclusion of the trial. So these attorneys are smart. They're looking ahead. They're looking, at, this is going to be appealed. And this always happens. So let's assume there's a serious procedural flaw in during the trial, and the defense attorneys, they don't catch it for whatever reason. And that would be grounds to overturn the verdict. But because an objection wasn't made and put on the record, you can't appeal that procedural issue. And there are a lot of cases that I've read where it would go to appeal, and what's known as a writ of certiorari wouldn't be issued to the lower court, i.e. send up the records, because the judge would say, wait a minute, did you appeal this during the trial? Is there a record of it? And if not, sorry. And even if they do issue the writ and they say, you can't do this ipso facto after the trial, you needed to do this during the trial itself. So the fact that this case made it to the State Supreme Court of Mississippi shows that she had some pretty good attorneys. And now I'm not going to go through, their appeal, what the appeal was based upon. There are quite a few. They had a lot of objections to the trial. So then comes the sentencing. If the jury finds the defendant guilty, the judge must impose some sort of appropriate punishment, and that's usually established by the criminal code. So a capital offense would be execution. Now, the judge does have discretion, and back then we had what's known as equity law and common law courts. And in a lot of the probate court cases, it would be in an equity court. So an equity court is a court that, in a civil case, you would say, well, there's no law that really applies to this. I have to go to the judge and just try to get a fair judgment. A common law court is that there's precedent, and the judge's hands are really tied as to what he can do about it. So the judge imposes some sort of appropriate punishment. Now, talking about punishment, and you see a lot of this in the current narrative about how slaves were treated in the criminal process, and that they, especially when it came to civil crimes, that they would be whipped. And the reason why they were whipped, and the judges speak to this, and lashes were sort of like how many lashes you would get, but whites were whipped too. If you didn't have property, you couldn't be fined. And so there had to be some kind of punishment in a civil case. So if a white didn't have property, that's the Admiralty law. That's what they did in the Navy, and it was just applied, because if you don't have property, how are you going to pay the fine? There had to be some punishment attached to it. And so, like, 40 lashes would be, quote, a death sentence if applied properly. So a punishment would be determined by the judge. It's not like today, it's a two-stage process. You get a verdict, and then there's an interval, and both sides present to the judge reasons why the sentence or the punishment should be lenient or harsh based upon aggravating or mitigating circumstances and such. So depending upon the severity of the crime, the judge may impose jail or prison time, fines, court-ordered counseling, or execution. In a capital case, it would be execution, the death penalty. And then the last step is the appeal. A convicted defendant has a right, a constitutional right, to an appeal. An appeal is when you take the case at the trial court level to a panel of judges on appeal. and there's no jury involved. They just look. They don't look at the facts per se and call witnesses. They just look, for the most part, was this a fair trial according to due process? So you have a right to an appeal. The defendant has the right to have a higher court review the criminal process in all stages, all the way from the arrest to the conviction in a criminal case. Every step of the process is subject to an appeal. And if there's any misstep, that could throw out the verdict and a new trial could be required. So it's very difficult to anticipate this because there's so much going on, so many moving parts. But the key is that here's a slave convicted, and I would say rightfully so, of a horrendous crime because the witnesses against her primarily were other slaves and free blacks. And somebody said, were they coerced to do it? Well, I don't think so. So a very complex system, very complex process. But here we have a slave in the antebellum period, going into the bellum period, with all the due process rights of a white. Now, when I say slave, like I said before, that's really the courts in probate cases were sort of with a wink and a nod saying, because you see this in the probate courses, who has title to the slave? And some of the judges are saying, because title, as I mentioned before, can't be based upon force and violence. So you think back, okay, here's a sentient being, a human being, with all these rights that people don't realize they have. At what point in time did that person become the property of somebody else or that person's labor? Show me the evidence. Show me the title. So as those slaves were captured in Africa, transferred to the slave traders, all they had was a bill of receipt, a bill of sales. They didn't have, quote, title. And so that bill of sales wouldn't stand up in any court. Just like, and these are some of the cases, you can't steal somebody's slave, sell it to someone, give them a receipt, and that person owns the slave. The real owner could come and reclaim that. It was based upon fraud. So the judges are saying, like I said, there are elected people, elected officials, but the courts, as we know, have a lot of discretion in changing the politics, sometimes for the good, sometimes for the bad. In most of the cases, the citations in these southern courts, they're not just citing each other. They're citing U.S. case law, the Commonwealth of Massachusetts case law. They're citing commentaries from Northerners, Southerners. So there's a community, sort of a community of the mind. What is the law in America? What is American common law? And how do you interpret statutory law, constitutional law, based upon American common law? So there's this community, and they're saying in these probate cases, your possession of a slave is based upon fraud and violence. You had no right to sell this slave. And the person now in possession with that receipt that they paid you for that slave, that doesn't stand up in court. So you trace that to the origins. At what point in time can somebody claim title to a slave? If the slave was captured under violence and forced to submit, they can't. And so through these it gets very complicated because they're in probate courts, family suing family member, who owns this slave, who owns that slave, where'd you get it, give me the receipt, so on and so forth. But it's sort of an illusion, sort of a habit of mind. These people are slaves, but maybe de facto, but not de jure, not by law. Because nobody, unless somebody served, do have indentured servitude, but that's something completely different, because you didn't necessarily own the descendants, the posterity of the person. But when it comes to, it's sort of like they thought they were slaves by law, but they were not. We think we're free by law, but we actually are not. I mean, what kind of a reality do we live in? But, people ask me, well, because they're coming up with many of you probably know this, HBO was going to do a series called The Confederacy, and they canceled it because these famous producers didn't have enough minorities on it. So they took their proposal to Netflix, and Netflix is doing a series titled The Confederacy. And the basis of the movie is that this Confederacy survived and spread slavery all over the place. I'm serious. That's coming to a Netflix. What's that?
A theater near you.
A theater near you. So let's talk a little bit about, and we don't have much time, but let me see if I could bring that up. This case, Josephine, a slave. This is in the title of the case, Josephine, a slave versus the state. Now that in and of itself speaks volumes. Here's a slave versing the sovereign state of Mississippi. Now think about that. And you see this all the time. Cato, a slave versus Florida. I mean, just let that cook for a minute. That a slave has standing to sue a sovereign state. Why? Because that person is a human being with fundamental rights, including the right to life, and to a certain extent the right to liberty, but substantially curtailed, and also to the right to the pursuit of happiness. I can't tell you how many cases there are of so-called owners of slaves being charged and convicted for abusing their slaves, for overworking them, for raping them, for all sorts of things. Now that doesn't, don't get me wrong, I'm not saying there wasn't a heck of a lot of abuse. We live in a fallen world, but the fact of the matter is, some were indicted, tried, and convicted for violating the rights of slaves. In some states, slaves could only work a certain number of hours per week. So, but this Josephine, sometimes we could miss it, but a slave versus the state. And this is the overview. Now, this is from the court records. Defendant was a slave who worked as a cook. She was convicted of murder after her master's child died of arsenic poisoning from tea. Reversing, this is what the Supreme Court, so what I did is I wrote the overview based upon everything that the court provided. I summarized it. Reversing, the court held that the trial court erred in instructing the jury that if it was satisfied from the evidence that defendant was an accessory before the act, it was to find her guilty as charged in the indictment. The court found that this was an error because she was only charged as a principal in the indictment. And the matter involved a substantial right of defendant because she was entitled to be informed by the indictment what degree of guilt she was charged with and what offense in law she was called on to answer. The court also found that a question whether the master had been having sexual intercourse with the defendant was competent and should have been allowed as evidence regarding the defendant's feelings towards the family. The court held that admission of defendant's testimony in the separate trial of a co-defendant was an error as it was not competent to the evidence on her trial. So in other words, during the trial phase, they brought in she was having a sexual affair with the victim's father. And the court decided that is not admissible evidence. So Josephine's attorneys challenged that. They objected when the prosecution during the trial was trying to bring witnesses in. Yes, Josephine was having a sexual relationship with, and as a result, there was jealousy. And as a result of that jealousy, she tried to kill both mother and daughter. What she did is she put arsenic in the tea for breakfast, and it was meant for the mother. The mother got very sick, almost died, but doctors were called in immediately, and she survived. But they tried to bring that in, this jealousy, because a lot of the other slaves were saying that, yes, she was having a relationship, an affair. Now, they're testifying against their owner, so-called. It was pretty, when you read through it, it's pretty persuasive. But the Supreme Court said, sorry, that taints the jury. That's not an issue here. What is an issue? Did she, with malicious intent, try to kill Mrs. Jones and Little Jones? And the court goes through, and it's, a lengthy process. The Mississippi Supreme Court goes through step by step. Where was the arsenic? Where was it bought? Who made the tea? Who drank the tea? Who got sick? Who didn't get sick? Did the doctor come in? Could the vomiting been caused by anything else? Was Little Jones sick prior to this? All these things. But the evidence is compelling against Josephine, but it was overturned on a flawed indictment, that early stage. She was charged with one and convicted for something else, not as a co-conspirator, but as the primary. That's what, because as the court's unwinding, so you have to think, well, the judge is reading, here are the charges, and the charges kind of evolved as the evidence unfolded. And that's what she was convicted under. So what happened on a retrial, don't know, the war. They may have retried her, maybe not. But you could just see how decimated, the court system would be as a result of the conflict. But it's really interesting how these judges are doing their best to keep society and the rule of law together. It's just unbelievable. And you read about, well, this judge was killed, this one's gone, that one can't find him, and other judges have to now ride circuit and hold trials. So things have changed, insofar as, the application of the rule of law in these states as a result of the war. But I'm thinking, as I'm reading through some of these cases, and they're still having elections for these judges and so on and so forth. Remember, they're not appointed with lifetime tenure. They're elected by the people. And just unbelievable legal talent and such. Put people today to shame, the way they write, the way they knew the law. And they didn't have that. You'll have a judge. Well, I'd like to look at this area of case law, but I don't have access to my books. And in one case, he sent somebody all the way to another state to get some citations, some books, so he could adjudicate a case. I can't remember which case that was. It wasn't this one. But here you have a thriving, organic, and I'm thinking society, the rule of law, and you're reading this, that you read about divorces, promiscuity, fraud, the relationship between internal improvements, who's getting the money from the state. So there's a lot of litigation in North Florida as a result of the treaty in which Florida was, the United States was given all that land in North Florida and what to do with it. And the Congress passed a law where Florida, you could use that, you sell off the land, but it has to be used for state internal improvements. And so the state's giving out these funds to build railroads. And one railroad suing another railroad, and one city suing another city because they want the railroad. It's just amazing. But you're reading this, you say, man, this was a real civilization. A real civilization. They weren't knuckle-dragging maniacs. I mean, it was really something, especially when you read about, probate cases, where who gets to inherit what. But insofar as you think, well, here they have, and they have all the regular, ups and downs of a normal life. Life, death, birth, marriages, divorces, businesses failure, hurricanes in Florida. You're thinking, and here come the men in blue. Here come the men in blue. It just is a real tragedy. And that's why this is speculation, but I'm convinced, based upon a preponderance of the evidence, that if the South would have been let alone, not only the legislature, but it would have been the courts that ended slavery. Because they would have made it very difficult to sustain it.
He was a slave.
Let me say, that started as a state case in Missouri, ended up as a federal case, but Dred Scott was cooked up. They used that as a test case. And he did, in a sense, prevail. Because when you think about 1857 and Taney's decision, sorry to say, Taney was correct insofar as slaves were not intended to be citizens, but free blacks were. But if you read Taney's decision, that issue about citizenship and whether it was about, does Scott have standing in a federal court? Is he a citizen? And if he's a citizen, he has standing. If he's not a citizen, he doesn't have standing. And slaves were not meant to be citizens. Free blacks were and could be citizens. Did they have all the civil rights? That's a separate issue. But Taney gets a bum rap, not only because of the timing of the decision, but because of that issue as, were blacks ever citizens? And the answer to that is, you can't say unequivocally they were not intended to be citizens. So 1857, that was like the Griswold case that led to the Roe case, that led to the Obergefell case. That was a trumped-up case. They wanted the litigation because what they do is an end run around the political process to get a desired result. So you take the Obergefell case that said same-sex marriage is a constitutional right. That's not in the Constitution. That's a state issue. But they went to the courts, and it started with they reversed an 1957 case in 1965 to make birth control available to married couples. And they said only married couples. And they created this right to privacy, which doesn't exist in the Constitution. It might be a natural right, but it doesn't exist as they portrayed it. But only for married couples. Then in 1973, they said, well, we have this thing called the Equal Protection Clause. We can't exclude unmarried couples. And then it went on and on, equal protection. Well, then we can't exclude same-sex couples. So the courts, they have a lot of, because the American people just don't understand what a fraud the U.S. Supreme Court has become, beginning in 1803 in Marbury versus Madison.
Amen.
and then 1819, and so on and so forth. But to rely on the court, that's, we shouldn't have, the average person, I'm paid to do it, but the average person shouldn't have to follow that, because government shouldn't be in their face all the time. It should be localized. So you can't expect people that work, have a family, other things, to know what the hell's going on in Washington, not to mention transnationally. So that's why we're we're in deep, I will say, we're in deep trouble. I'll put it that way.